Good evening, colleagues. Our colleague yesterday, the UK judge Anissa Dangi, reminded us about the campaign waged there in the 18th century against the slave trade by William Wilberforce. Yesterday, Chief Judge Anna Blackburn-Rigsby from the US reminded us of the sad history of slavery there, culminating in the devastating Civil War, which still has repercussions in the United States today. In Australia, we have our own history of slavery, including the practice known as blackbirding, where Pacific Islanders were hijacked as slave labour to work in the North Queensland cane fields, and of course, more recently, a whole generation of Indigenous children, known as the Stolen Generation, forcibly removed from their families. This latter chapter in Australian history revisits judges in the criminal justice system on a daily basis in the form of mental illness, drug addiction and domestic violence, both as victims and perpetrators, and the shameful rate of Indigenous imprisonment in Australia. Slavery, therefore, has a vast human cost, which continues for generations. And so all civilised people in modern times condemn slavery, which we thought had been eliminated. However, the more recent trend of human trafficking, sometimes for enforced sex work, sometimes for enforced labour, sometimes for enforced marriage, represents a significant return to effective slavery. The justice system has a very important role to play in eliminating this scourge, especially those of us involved in the justice system in developed countries like Australia, where sadly our citizens are also often the consumers of this product of modern slavery. So to be given the opportunity to contribute, even in some small way, towards the elimination of this scourge is an honour and privilege for me. I would like to add my voice to others in thanking His Holiness Pope Francis for his leadership and contributions towards this goal, and also to the Pontifical Academy and Monsignor Sorondo for hosting this important summit. I would also like to acknowledge the considerable efforts of the President of the International Association of Women Judges, Justice Susana Medina, for coordinating our attendance here as a large group of women judges from around the world. There can be no doubt that trafficking in human beings is a serious breach of human rights. What I want to do now is move on to discuss the situation in Australia and make some modest suggestions about some solutions which we might adopt as women judges in particular. Australia is a signatory to the Trafficking Protocol and is a regional leader in the Indo-Pacific region towards the total eradication of human slavery and trafficking, human trafficking and slavery. Regrettably, our region is also the source of a significant number of the victims of these practices worldwide, and also the source of the vast majority of offenders in our region. Australia co-chairs with Indonesia the Bali Process on people smuggling, trafficking in persons and transnational crime, which includes 48 member nations and is the principal mechanism for Australia's regional cooperation in this area, providing a forum to work on this issue within the region. There are significant issues and challenges in the Indo-Pacific region which create fertile ground for people trafficking, slavery and slavery-like practices, and our colleagues from the Philippines have identified some of those today. They include densely populated nations with considerable poverty, nations destabilised by lengthy wars and natural disasters, serious environmental and sustainability challenges, especially in the Pacific, with some small nations threatened with destruction as a result of the impact of climate change, where the people want to leave to improve their lives or perhaps even have a life at all. People in our region then are particularly vulnerable to the promises and offers of people traffickers for a better life, offering them apparently well-paid legitimate work in wealthy countries like Australia, only to find that they've been trafficked into sex work, or that job involves fruit picking in rural Australia, in either case with a large debt still owing to the trafficker, which they are expected to work off, undertaking that sex work or for virtual slave wages, whilst in a state of virtual imprisonment with their passports retained by the trafficker, their living conditions crowded and squalid and their movements severely restricted. All of this, of course, exists within a context, namely the relative wealth of Australia, with a significant consumer appetite for all commodities, including cheap goods, cheap labour, and child and adult sexual services. The 2016 Global Slavery Index estimated that there were at least 4,300 people in Australia in what they referred to as enslaved by criminal syndicates, forcing them into prostitution and work. So the problem is real and current in Australia, albeit not obvious and sometimes invisible. In addition to enforced sex work and forced labour, Australia has also identified forced marriage of women and girls as a third area amounting to human trafficking and slavery-like circumstances. The reason why this is often hidden and invisible in Australia is because most, if not all, of these trafficked people in fact initially come to Australia on lawful visas, work visas, tourist visas, and increasingly on student visas because of the large overseas education industry which has flourished in Australia. Australia is a large island nation, and like New Zealand, our visa entry requirements are very strict. We do not have common borders with any other nation, and so we do not have the history of some nations of trafficked groups being smuggled across borders in lorries and similar. Most trafficked people come lawfully on visas arranged and paid for offshore by traffickers, with promises of legal work or genuine study courses, which in fact either never did exist or are short-lived. So the victims then are not just victims of trafficking and are enslaved, but also in breach of their visa conditions, so at risk of being taken into detention by immigration authorities and deported. It's hardly surprising then that these victims are reluctant to come forward and in fact often lead lives in the shadows. Anti-slavery trafficking and human trafficking provisions have been part of Australia's federal law since 1999, which have been amended along the way, including in 2013 adding forced marriage to the criminal code as a slavery-like offence. Despite that, however, despite the numbers of people estimated to be victims of human trafficking and slavery, there have been relatively few investigations, only 604, fewer prosecutions still, and only 7 convictions between 2011 and 2016. The reasons for this are complex, including the visa and immigration issues already mentioned, and also victims' fear of retribution. The Australian Government strategy to combat human trafficking and slavery was established in 2004 and is founded on 4 central pillars. 1, prevention and deterrence. 2, detection and investigation. 3, prosecution and compliance. And 4, victim support and protection. As judges and prosecutors, we have a role to play in each of these, always, of course, within the constraints of our professional obligations, particularly those for judges. Particularly as women judges and prosecutors, we have a special role and insight because of the clear recognition that tackling human trafficking and slavery is also an important means of addressing gender equality and ending violence against women. Global figures indicate that women and children are especially vulnerable to exploitation. For example, the UN Office on Drugs and Crime estimated in 2014 that 70% of trafficking victims globally are women and girls. The experience in Australia supports this finding, it being identified primarily as a destination for women and children subjected to sex trafficking, but also trafficked to Australia for forced labour and forced marriage. Some of these 4 pillars are outside our expertise, but others perhaps are within, even though perhaps more subtly. The pillar of detection and investigation. For law enforcement agencies and prosecutors, this is fairly obvious, but for judges, perhaps not quite so much. However, in my view, we can play our part. As my colleague from New Zealand yesterday, Justice Susan Glazebrook, said, if sitting in the criminal jurisdiction, we may identify, in an apparently straightforward case, a victim who is a recent arrival to Australia who seems particularly cowed or overborne, who in fact may be a victim of trafficking. Perhaps a defendant may come before you, often a young woman charged with drug offences or perhaps a minor stealing offences, who is in fact trying to escape a trafficked situation. As judges, we can seek to refer these people to the relevant anti-trafficking authorities, and perhaps this may lead to the identification and prosecution of traffickers. This always, of course, requires the cooperation of a victim, which doesn't always happen for all those complex reasons to which I've already referred. However, my point is that we can and should be alert to the possible backstories and to go that extra distance where we identify trafficking. The same considerations apply to those of us who are hearing family cases, cases involving the care of children, and of course cases involving individuals who are in breach of visa conditions, immigration law and labour law prosecutions. Victim support and protection is one of the 4 pillars to which I referred. We may not be able to have much in the way of a direct role in this area. However, as individuals and as a group, we are people of relative power. We may be able to add our voices to our local professional bodies when law reform is needed. Just in July this year, a Parliamentary Joint Committee on Law Enforcement from the Parliament of Australia produced a report on an inquiry into human trafficking, slavery and slavery-like practices. There were submissions from legal professional bodies, and they are calling for a national compensation scheme in Australia for the victims of human trafficking and slavery. This has in fact been adopted as a recommendation by this joint committee. As judges, we may be able to contribute to our local professional bodies in this role of advocacy. In addition to this Parliamentary Joint Committee and their recommendations, Australia is also currently considering enacting a Modern Slavery Act, similar to the United Kingdom Modern Slavery Act, which was enacted in 2015, and to the establishment of an anti-slavery commissioner whose role will include the investigation of trafficking and slavery complaints. Amongst other provisions, this proposed legislation would compel large companies to report annually on their efforts to safeguard supply chains from slavery, with their responses then available in the public domain so they can be viewed and boycotted by consumers if they don't measure up. This then, in my view, amounts potentially to a corporate version of the Nordic model of criminalising the consumers of the sex trade rather than the victims, which is a model, as I read, supported by the Pontifical Academy as a step towards eliminating the demand for one of the products of slavery. This proposed model in Australia identifies the need for companies to be held accountable for their supply chains and force them to investigate and disclose whether along those supply chains are goods produced as a result of modern-day slavery. It is a model which deserves close study and support. Each of us here represents a nation state, and we're here at a meeting in the Vatican State. Are our governments, institutions and large corporations ensuring that their own supply chains are free from slavery? But it can go further. Each of us is also a consumer. We can make a personal commitment to avoid goods which are likely to have been produced through slavery. Can we truly justify the retail price of a T-shirt of $3 or even less? How can it ever be possible to produce and sell a box of strawberries a box of strawberries for less than $1? These are things that we can do as individuals. You'll have to bear with me whilst I get back to this because it's gone away. Anyway, I'll make it up from here. These are things that we can do, and it's part of what's being done in Australia with a view to the Modern Slavery Act. These are just some suggestions based on the Australian model that we can perhaps consider, which I put forward to you for your consideration. Again, thank you so much for the opportunity to make what is only a small contribution to this debate. I hope that this very powerful group, of this very large group of powerful women, can come away with some suggestions that are more concrete, that amount to concrete solutions and not just a dream to end this scourge. Thank you.